have the great privilege of introducing our guest for today, who is here visiting to contribute to our project on compensating victims of terrorism. I want to tell you a little bit about Don's story. In 1991, he studied torts in Whitehall. He studied with Professor Banks, Professor Bell, Professor Wiseman, Professor Lake, the same folks that you're studying with. And in 1993, he graduated apparently very well prepared for a career in cutting-edge litigation. So go SU, they've done. 1997, just 4 short years later, he worked with Motley Rice's attorneys on behalf of state attorneys general in the historic lawsuit against Big Tobacco, resulting in the largest civil settlement in U.S. history. He was also involved in Indiana's first contractor liability verdict and first premises liability verdict for wrongful exposure to asbestos. He continued to work for victims of aviation disasters, defective medical devices, and drugs, and occupational diseases. And then 4 short years later, in 2001, he began to put his drive and expertise to work on behalf of the victims of the 9/11 attacks. He has represented over 50 families who opted out of the Victims' Compensation Fund to seek greater answers, accountability, and recourse. Don also manages anti-terrorism litigation associated with the 9/11 terrorist attacks as lead attorney of the 9/11 Families United to Bankrupt Terrorism. This is a groundbreaking litigation effort designed to bankrupt the financiers of Al-Qaeda. A little bit more bragging about Don. He was, in 2009 and 2010, he was named in the New England Super Lawyers, in the 2010 edition of Law Dragon 3000, and the 2011 edition of The Best Lawyers in America. Long past being a law student now, he's regularly called on by television and radio broadcasters and newspapers. And now, as adjunct professor at Roger Williams University School of Law, Don now calls on students in mass torts classes. So please help me welcome Don Miller.
I used to sweat this much in Professor Banks's class. I wasn't expecting warm weather. I was expecting the weather I remember being here, 90 to 93. It's a pleasure to be here. I don't know who wrote any of that, and it's embarrassing to listen to it. I think it's much more accurate to tell you that when I took Professor Herzog's torts class in 1990, I got a C+. And part of the reason for it was he had on his question, in his exam, a question, does a dog only have one bite? And not having done any outlines for that class, I simply wrote as an answer, yes. And that didn't go over so well with the professor. But now I find myself in mass torts. It's what I do for a living, and that's what I teach at Roger Williams Law School in their honors program. So it's a pleasure to be here. I'm excited to be back. And I want to share with you some work that I've just been doing for some 9/11 victims. Back in 2002, we filed the very first opt-out cases on behalf of people who chose not to go into the Victims' Compensation Fund, but chose to go into the court system, the civil justice system, in order to do more than just participate in a no-fault scheme, but to actually take a full advantage of what the civil justice system offers and what it's designed to do. I represented 60 people who were on the flights and in the towers against the airlines and aviation security context for 9/11. But I also represent 1,700 people who died on September 11th and their family members in what's called the material support or anti-terrorism litigation. And basically what that litigation is it's litigation on behalf of the families to disgorge the Al-Qaeda financial networks with some statutes that we have in the United States that allow us to bring actions here against folks in the Middle East and other places that actually provided either financial or some kind of material support to Al-Qaeda in order to carry out the 9/11 attacks. So my last 9 years have been focused on representing the 9/11 family members. They're often referred to as victims. I try to stay away from that for many reasons, but the truth is that these folks, 10 years later, having just had their 10-year anniversary of the event, are still suffering in ways that are unimaginable. And the tort system was a very small part of their process of dealing with what happened that day. And so it's an interesting opportunity to have the ability to practice law, use the civil justice system for all of its purposes in a way to help families that have gone through truly the most devastating thing that hopefully will ever happen in our lifetime. So because we just settled last week, you may have read the very last case involving folks who opted out of the Victims' Compensation Fund. The tort system, as it relates to the human losses, is completed. What's left now are just commercial claims and property claims, and they're all venued down in the Southern District of New York in federal court. So because I've just finished getting ready for that trial, because I've sort of geared my thoughts around that for 9 years, and because I was so anxious to give that opening and closing, I'm going to bore you with what I was planning to do to some extent. 9/11 is one of those events that everyone has their own. Everyone will remember where they were. Everyone will remember what they, the person that they knew, or the person that they knew who knew somebody who was involved with 9/11. But there are a lot of things about 9/11 that are just sort of fundamentally misunderstood. And so when I teach a course at Roger Williams called 9/11 Litigation, and it goes through the Victims' Compensation Fund, the tort system, and the terrorism litigation. When I teach it, I ask my students why they're taking the class. And inevitably, there's somebody who always says, well, I hear you try to make the students cry. I now find that to be a challenge, doing this now for the 7th year, that if I don't make them cry, that I've somehow not conveyed the material properly. So if some of this is difficult material, I apologize, but I think it's sort of become my charge. Let me go through some of the backgrounds of what the 9/11 litigation is about, and then we'll talk more specifics about the actual case. And in particular, we all know that there were 4 flights that day, 2 leaving out of Boston Logan Airport. Flight 11 was the first to take off, and Flight 175 was the second. There was a French camera crew that actually had the just random ability to actually record the first plane hitting, and it hit at 8:46. That was an American flight. The checkpoint at that flight was run by a company called Globe Aviation. Before 9/11, TSA did not exist, so the litigation that we're dealing with deals with private security companies at these checkpoints. The second plane coming out of Logan hit at about 9:02. The case that we were just about to try was on behalf of somebody named Mike Bavis. He was a passenger on the second flight. This is actual footage from inside the World Trade Centers as they're trying to evacuate some folks. And the recordings that you're going to hear are recordings from the actual firefighters at the time trying to figure out how to get people out of the building safely. The security company for the second flight was a company called Huntley. And irrespective of the role of the airline in making sure planes didn't have weapons, the security companies were privately run corporations contracted for by the airlines. There is no footage. There is some footage of this plane hitting through a parking lot surveillance, but the Flight 77 flight, it left out of Dulles Airport. I have some footage of the checkpoints there, but the Dulles flight was a company called Argenbright. Although it was an American Airlines flight, it was actually United Airlines that was a custodial carrier, or the carrier that was responsible for the checkpoints out of Dulles. And then the last flight was Flight 93, again, another United flight. Flight 93 took off from Newark Airport, and this was the flight it had only 4 instead of 5 hijackers. And on this flight, you may know that several of the passengers were able to almost get themselves completely into the cockpit to commandeer the flight. This flight, at the recovery in Shanksville, Pennsylvania, 14 weapons were recovered at the ground site, weapons that should not have been on board that plane. And that was also Argenbright, which was contracted for by United Airlines. Inside the buildings, there were obviously thousands of people that were killed when the 2 towers collapsed. It was the second tower that was hit that was the first to come down. And these are the actual recordings of the firefighters interacting. during that. The exodus from the city was such that every hospital in New York City was braced for this event by having everybody that was on call, not on call, report to the hospitals and wait with the gurneys outside the hospital to take in people, and nobody showed up. This wasn't an event that had many injuries. Unfortunately, it was an event that either you made it out or you didn't. So that's the background. And so what happens is, as a result of this event, within 10 days, Congress put together a bill that was designed to stabilize the aviation industry. It's referred to as that CISA, ATSSSA. It's the Air Transportation Safety, Security, and Stabilization Act. And in it, one provision was creating the Victims' Compensation Fund. But essentially, it provided about $15 billion worth of grants and loans to the airlines in order to get them back up in the air. You'll remember that there was about 4 days that the airlines did not fly. At CISA created a legal question immediately for everybody who had a loved one killed or injured. And that was, do you participate in the Victims' Compensation Fund, a relatively historic concept of a compensation fund, a no-fault scheme, not insurance money from a defendant that may have done wrong, but U.S. tax dollars put into a fund administered by a single person, Ken Feinberg, with no review? Or do you go into the tort system, run the risks of burden of proof, all the things that you learn in the tort system? So these are folks that came to me with those questions without having any background to be able to say, this is what we did in the last case like this. We had to answer questions for folks like this. This is Cece Lyles. Her husband, Lauren Lyles, came to us. He missed this phone call because he worked a third shift as a police officer, and he was sleeping when his wife called. A flight attendant on the last flight called from the airplane. So obviously, besides the human tragedy of that kind of phone call, we learned from this phone call that there were weapons on the plane, that she thought there were 3 hijackers, there turned out to be 4, that they were aware in flight of other planes having already hit the World Trade Centers, and that she anticipated, based on where they were going, that they weren't going to make it. From the towers, now you have an impact on the building. You have 2 towers that are standing. Both are now engulfed in flames. You've got folks that are above impact lines. These are this is one recording. This was actually used in the Moussaoui case, you may remember, in the Eastern District of Virginia. This is a recording of one person above the impact line in the second tower that was hit. Oops.
Investigations made. What's the telephone number? I'm waiting for MC to pick up. What's the telephone number? The very street. You can do anything there, 4AM, 2623. 2623. On 105th corner, northwest corner, right? Right. At number 2 right. Lady was students in his office. We're not ready to die, but it's getting bad. I understand that. We don't have to all the apparatus there. I'm trying to let them know where you are. Oh, please, Harry. All right, sit tight. We'll get to you as soon as we can. There's some staying up at the smoke fumes there, man. That's all we can do. Stay on you. Let's where you guys up to. We're getting there. There's a few that get there, and I got one too. I understand that, sir. We're on the way. He's on 100th floor, northwest corner. Yeah, no problem. Operator? Yeah, come on, man. Okay, we operated this way. And then you keep it because you get lots of people up here. I understand.
So I'll end it there. That actually, unfortunately, that tape actually ends with the towers coming down. Again, now you've got a guy above the impact line, knowing he can't get up, talking to the people that he thinks are the only way he's going to get down, and he has no answers. He's got lots of people around him. He's got acrid smoke. After I play this last one, I'll tell you why I'm playing these for you. This is the only survivor of an entire squadron at the Pentagon. His entire squadron literally died around him, and when he came to, he had burns over 40% of his body, and the nose of the plane was literally, of the Flight 77 plane, was literally within 30 feet of him. His name is Kevin Schafer. After he recovered from his injuries as best he could, he actually served on the 9/11 Commission to investigate what happened.
Hello, my name is Kevin Schafer. I'm a medically retired Navy lieutenant. I was working in the Pentagon for the Chief of Naval Operations when the September 11th attacks struck. After Flight 77 crashed through the Pentagon and into my space, I was immediately blown to the floor, and I knew I was on fire. What had been a live and bustling space all around me was complete carnage, and as I stood trying to extinguish the flames on my body, mainly my head, which I knew was engulfed in flames, I finally got the fire put out, and I realized that everyone around me, my close office mates, co-workers, and professional friends who were standing and sitting just several feet away from me, were gone. I managed, however, to work my way under and around that obstacle, and as I continued to crawl to space, I realized that I was succumbing to the thick, acrid smoke. I'll never forget what that tasted like and what that felt like and what that smelled like. Across the carnage, I could see through the smoky haze the light of day. And as my adrenaline surged, I raced across the space, crawling over the debris, stood up, and exited what was quite obviously a very large hole that had been freshly blown out through a brick wall. I had my burnt arms and hands extended in front of me, and I could see that flesh hanging from my arms and my hands. The next individual I recall coming toward me with his eyes wide open was a sergeant in the Army, and he was what I call my angel. And Sergeant Workman looked at me. We had never met before, and I looked him in the eye and I said, "Please don't let me die." And they went back to work on me, and I then realized that they were tugging at my hands and my fingers and causing me a great deal of discomfort. And then I realized what they were doing when one of the doctors yelled out for the ring cutters, because as hopefully you can see now, on that morning I was wearing my wedding band on my left hand, just as I am now, and my Naval Academy class ring on my right hand, and they both mean so much to me. They called for the ring cutters to remove them, and once again I yelled out, "Stop!" And about 20 people stopped in their tracks. And I'm told it was a sight to see, but I managed to focus all my will and strength at that time and pull off my wedding band and my class ring and hand them over safely to the personnel standing by my bed. And I said to myself as I lay back on my pillow, "Okay, now you can save my life."
So 9/11 happens. You've got a victim on a plane. You've got a victim in a building, both of whom died. And you've also heard the account of somebody who survived and almost died twice. As a lawyer, we're trained to do what we do. We're trained to be in the courtroom. We're trained to learn facts, to discover information, to try to get the best outcomes for people. But in this context, it was so much more, it seemed. And yet what I realized in representing these folks is that it's not. We've given in so much to believing that the civil justice system is only about compensation. And it's driven by people who have motives only about money and attorneys that are driven by contingency fees. But one of the most powerful things in the world about the civil justice system is its ability to get information. And so what these families wanted, the 96 families that chose not to go into the fund, what they wanted was a chance to run the risk of the burden, to run the risk of litigation, the time, to see if they could find out why it happened. Why 19 for 19 hijackers got through checkpoints that by federal regulation they're required to keep weapons off of planes, and yet weapons were on every single one of these planes, and they were used to carry out these hijackings. So I began to realize that in representing them and advising them whether or not to go into the fund or go into the litigation, there is a completely legitimate purpose to the civil justice system that we all forget and overlook. That is an absolutely appropriate way for families to deal with what they've lost. The Victims' Compensation Fund worked for many people. 98.5% of the people that suffered that day went into the fund. I put 50 people through the fund pro bono because I knew those families could not suffer the risks, the time, the burden, the difficulty of litigation, but I also knew that the Victims' Compensation Fund was not based on numbers or valuation that even came close to what the tort system would value a claim at. So we did that as a pro bono, as a service to those clients, and we don't ever criticize folks who chose that route. But we did become sort of the leading group in representing folks who wanted to do something different. And so I represented 56 of the folks who'd opted out directly, and all 96 as the court-appointed liaison counsel for the fund. And so when talking about their options, this is what we had to tell folks who came to us who had lost people. You can go into the fund, it's no fault, it's a compensation scheme. Once you start your application, you're committed to it, you can't back out of it. It's a scheme that's run by Ken Feinberg, a special master, who has no oversight or review. Once his determination is final, it's final. The funds for this, $7 billion were paid out in death claims, and those funds were paid from federal general treasury dollars. And there was no ability to ask questions, get answers, accountability. The folks who went into wrongful death, they actually had different motivations, and as a result, their outcomes were different. The only public information I can share is on average, the death cases for compensation fund claims were about $2 million, $2.1 million. On average, the wrongful death negligence claims were over $5.5 million per claim. But some of those folks received 20 and 30 and 40, significantly more depending on their income and their income losses and their state law that would apply, and others received less. But on average, we're talking about $5.5 million. Then there are questions about product liability. Did Boeing have responsibility when it was selling aircrafts to companies like countries like El Al for Israel that did have impenetrable doors, but these doors didn't? Is there a product claim? And that's been explored, and that's still being litigated actually for some of the property claims. For property claims, there are RICO claims that have been implicated by 9/11. The Anti-Terrorism Act, which basically was born out of a loss that's very personal to our school, to Syracuse, was Pan Am flight. As a result of Pan Am and the leadership of the families from the Pan Am litigation, Congress passed the Anti-Terrorism Act. And it's been amended, and that's used to empower victims of terrorist activity to actually go after in civil context those who materially support Al-Qaeda, and we're doing that for the 1,700 families we represent. For those people that were not U.S. citizens, but actually were affected by 9/11, killed or injured by 9/11, but from foreign countries, the Alien Tort Claims Act, there are about 200 people that we represent under the ATCA for this context. And the Foreign Sovereign Immunities Act, which has a lot of implications because some of the folks that we've sued include Saudi royal family members and folks who are claiming immunity under the FSIA. And those issues have actually gone up to the U.S. Supreme Court. So you got to go through all these issues with your client, and you got to ask them what their motivations are, what their willingness is to do either. And you'll find that some folks actually chose not to do anything. There are actually some folks who didn't do the fund, didn't do the litigation, didn't do the terrorism litigation. So this is very much a personal issue. For some reason, with 9/11, it seemed even more so that you couldn't really give anybody your advice about what you thought they should do. but you had to give them as much information as you could, even though we're acting in a vacuum. So the fund pumped out awards to 98.5% of the families. And so the reason why I showed you those clips is because if we're talking about the victim's perspective, we all have a concept of what that must mean, what that must feel like, even if we can't put ourselves in those shoes. So in the 9/11 context, setting aside economic loss, in the tort scheme, the two big areas of recovery in a claim like this, if you're only focusing on compensation, which is all the Victims' Compensation Fund did, were the pre-impact fears, the person on the 105th floor calling, I have kids, I'm too young to die, it's acrid, I can't see, it's hot. There's that. For Mark Bavis, the person that we were about to try this lawsuit for, he had 21 minutes of knowing on Flight 175 that he was about to die. They were aware of the Flight 11 on Flight 175. So we had 21 minutes of true fear, which the court adjudicated was compensable under Massachusetts wrongful death law, which was the damages component of that claim. And then there's what's left behind, the spouse, the children, or in Mark's case, the mother, who is the next of kin, who under Massachusetts law would have love, society, support, companion type claims. So I want to get from you all, I'd like to do this with my class because the range is so great, but does anyone think that it's impossible or wrong to individually assess these non-economic claims? Is it wrong to put a value on what one person experienced on the 105th floor versus the person who was in the Pentagon and survived, or the person who was immediately killed in the Pentagon and didn't have a minute? Does anyone think 9/11 is that one case where we just shouldn't ever have made a distinction between folks like that? And I'm going to start calling the people I sat in class with if I have to. And if I have to, I'll call them my old professors. Do you have any?
I mean, I think the challenge, you know, and for lack of a better term, it's the fairness aspect. I mean, how, from an economic standpoint, everybody feels very differently and reacts differently to these types of tragedies. So the people left, I mean, there's no fairness across the board. And so how do you handle that, you know, as a lawyer, if it's your particular client, but, you know, you have many clients.
Right.
So who's
Do I have a
to say that
conflict?
one person's pre-impact terror damage, you know, if he had 21 minutes, what if mine had 10?
But yet, at the same time, isn't that what, does anyone feel differently? Just instinctively?
How do you do it fairly?
I don't think it's wrong, I just don't think it can be done. Like, there's no money that can.
So when we get to that point, and that's a common response, when you get to the point nothing can be done, do we give up on the civil justice system? Do we create a fund, or do we just literally say this is just too hard in this context? We don't do it. What's the and then? And you're not alone. That's actually a very common response. This is just so difficult. Maybe our system's not set up. Does anyone think that the civil justice system isn't set up to do that?
But, I mean, what do you do in normal civil cases? What's the burden for, I mean, obviously if you can do it in one case, there has to be some kind of burden that you can try to apply to other cases.
I represent 1,200 women who have a pelvic mesh in them that's defective, that's causing tremendous injury. Every injury is very different for every woman, but they all have the common denominator of one bad product. What does the tort system do for them? It's in one lawsuit because it consolidated in multi-district litigation. The system individually treats them, but tries to be as efficient as possible as doing that. So in the end, from my perspective, what we were telling these families is the court system is not only capable of doing it, it's the founding principle. The tort system is designed to manage individual claims and value life every single day, and has since it's been in this country. Even though 9/11 seems for so many people to be that we could have never imagined event, and it affected so many people at once, our system is not only equipped to do it, it's uniquely equipped to give people, if they choose that route, the opportunity to get out of that system what it is that's important to them. And for some of these families, it wasn't about the money. It wasn't about valuing these different things. It was about, why did it happen? Let's get to the value of that. Does anyone think, can anyone throw out a number what you think a pre-impact, you're Ken Feinberg, you got to come up with a number. Government says you got to do this. We can't run away. We got to do it. Is there a number you would put to that? For that pre-impact, the 21 minutes if you're on flight 175 or being on the 105th floor before it comes down? Let's say you got to treat everybody the same. Would it be above or below $1 million to have 21 minutes of fear?
About
$1 million. Does anyone think that it should be below $1 million? How about above? Does anyone have a number that's, there's got to be some liberal in this room. Does anyone think it should be $2 million? What about the loss of a spouse? Now, this is for the rest of his life. Mark's mother was 71 when he died, and she's entitled under Massachusetts wrongful death law to collect for the rest of her life expectancy. She's now 81. She's vibrant. She's beautiful. She's absolutely heartbroken. And she has, under this wrongful death law that's existed in Massachusetts for every type of wrongful death claim, a lifetime of loss of love, grief, society, companionship, support. What would you give, you should put mother here, what would you give to a mom who lost a child? Ken Feinberg, you got to make a decision. Kelly, what would you give?
More than 100,000.
Oh, you cheated. What is it?
But isn't that a more, I mean, I don't have a number, but isn't that a more concrete number as opposed to the one above it? I mean, you can factor in people's potential.
There are economists, judges have allowed me to put economists up to give, you know, if you were to go pay somebody to do your laundry every day for the rest of your life, I can tell you what that would be worth per hour. Those are very difficult witnesses to put on the stand and not have your jury snooze out on you. But you're right, there is a economic basis to do that. So that's a little more calculable, even if it's still theoretical. Does anyone think that number should be under $1 million? Somebody has to believe that it's worth a lot more than $1 million, right? Just give me one hand so I can move on with this and feel better. All right. Well, so Ken Feinberg did do that, and he came up with these numbers. So for the person for the 125th floor, that number is $250,000. Everybody got $250,000. That is every estate who had a wrongful death claim where there was whether there was a minute or 45 minutes, like one of the flights, of fear, they got $250,000.
So they didn't do it literally per minute, you just.
Per person. This is too difficult. I need to get people into the system. The number's $250,000. Now there's a little difference when you have somebody who survived. Very, very few people survive like Kevin Schafer. That number doesn't apply. This is for wrongful death. But for every spouse and child, I can play some horrific videos of children telling you about what they lost with their father or their mother dying on that event. Every child received $100,000 as value under the Victims' Compensation Fund for the loss of their parent. And every spouse received $100,000. So in Mark Bavis's context, he died, and his mother is the sole next of kin. His claim, and if you actually were talking about a state in which economic loss was not recoverable, his claim was worth $250,000 plus $100,000 for the mom. And that would be the recovery under the fund. Now, Ken Feinberg was, if you saw him here or if you've seen him before, he's very charismatic, very intelligent. He got a lot of people into this fund. There are a lot of ways he did it, and it's not appropriate here. If you didn't have the camera, maybe I'd tell you more about it. But there are a lot of ways that he got participation, but this was his basic scheme for the non-economic component.
And did people know this when they were signing up?
About halfway through, he started to disclose how he would start to calculate this out.
I mean, those numbers, I mean, they're just staggeringly low.
And
$100,000?
see, I knew I'd find one of you in the room with me.
But I mean,
And that's the point. So there are folks who legitimately said, let's do the tort system because the numbers aren't right. It's not just compensation, it's just compensation. It's truly this amount of money to get out of the system and to not sue the airlines so the airlines are stabilized. The act that created them is the Airline Stabilization Act. And Ken Feinberg did that. It was a $7 billion payment to these families, but it kept the airlines out of bankruptcy, although all of them filed bankruptcy at least twice during the pendency of the litigation anyway. So we have claims that went forward, and so let me tell you a little bit about what we had to do. So back in 2003, we had to fight the good old Paulsgraph fight. Who was able to sue, and to whom was the duty owed? And so in this case, the airlines actually challenged folks who were killed in the building, saying they did not have, it was not foreseeable that they would be, a duty would be owed to them. And so there was actually, believe it or not, litigation about whether or not the airlines were at all liable to the 2,500 so people who died in the buildings. And of course, the end result of that litigation was that there was a duty owed. And during that whole process, it was conceded that the folks on the plane, the defendants absolutely had conceded their duty to the folks on the plane. But then the airlines started to say, so we owe this duty to everybody, but, and Condoleezza Rice repeated this, nobody knew 9/11 could happen here in the United States. We're a country that doesn't ever have terrorism. How could anybody have anticipated an event like this? How many folks know Family Guy? I tell you, I'm old enough where Simpsons was my show in law school, but when it first started, by the way. And Cosby, I think, was the other. Family Guy is pretty irreverent, pretty inappropriate. If there's some controversial issue, and 9/11's become very controversial, Family Guy will be the first to jump at it. Well, Seth MacFarlane is a Rhode Island School of Design major. He's not an expert in aviation, but this is what I guess he thought would be funny, one of his skits.
Sorry, little man, everything gets x-rayed. Wait, there's really no need to... On the good ship, lollipop, it's a sweet trip to the candy shop where bonbons play on the sunny beach of Peppermint Bay. Let's hope Osama bin Laden doesn't know show tunes. God, I hope I get it. I hope I get it. How many people does he need? How many boys? How many girls?
All right, I heard a couple little laughs, and it's uncomfortable to laugh about it, and it's kind of funny, but it's really kind of not funny.
I think he can do it, so he was supposed to be on one of the planes.
Well, he actually was supposed to be on Flight 11, and he backed out. But that's not why I showed this clip. What's the most remarkable part of this clip, to me, is that this clip was conceived, produced, and aired on May 30th, 2000, a year and a half before 9/11. So when Condoleezza Rice and others got up in front of the world and said, we had no idea that Al-Qaeda would ever do this in the United States. I'll grant you, because he's from RISD, this is a fictitious town called Quahog, Rhode Island, I guess near where I grew up. But Seth MacFarlane, a cartoonist, put bin Laden duping a checkpoint a year and a half before 9/11 in a cartoon on Fox. So you would have to assume that he at least thinks somebody got the joke if he's going to bother to do it. Out of respect to the family, he pulled it from the DVDs a year and a half later when 9/11 happened. But this was on the air a year and a half before 9/11, and it exactly focuses on what this litigation became about. The checkpoints, how did they become penetrable? How was it so easy to get 19 people through? I almost went to jail for this videotape. Let me play this for you, and I'll explain that a little bit.
They are Majid Moked and Khalid al-Midhar. Both set off the alarm and are directed to a second magnetometer. Moked fails again and is wanted by hand. Both are allowed to proceed to their flight. 7:30.
All right, so there's a videotape at Dulles. It's the only place that has closed-circuit TV. Two of the hijackers go through. They set off the alarms. They go back. They're put through the alarms again. They go back. The guy wands them, and he sends them off. Not once do they stop. Now, federal law says if you set off an alarm, you cannot pass that passenger through to the airport or to the plane until you identify what set off the alarm, inspect it, decide whether or not it's prohibited, and then make a determination whether or not you can let that passenger through or that device through. That didn't happen at Dulles at all. They, in fact, wandered them through and didn't do any follow-up. The day after this was liberated, the TSA came out and issued a statement that said the videotape demonstrates the inadequate security procedures in the pre-9/11 era. Immediately, acknowledging immediately, pre-9/11, we did not have a priority of making sure the checkpoints were clear. What was used on 9/11? Well, this is one of the conclusions of the 9/11 Commission. Not only was 9/11 imaginable, it was imagined. Back in August of '99, one of the principal scenarios was a suicide hijacking operation here in the United States. The FAA had been advising the airlines for years about the risk and the increasing risk of something like 9/11 happening. So we had to boil this down to the Flight 175. These are the hijackers from that flight. There were 56 people on board, 9 crew members included. Remember, United took money from these hijackers. They're paying passengers invited onto their aircraft to fly with the other passengers that day. They used knives, mace, threat of bomb. Huntley was a security company at that checkpoint, and when we went through this whole process, in the beginning in 2003, the judge said, this is about duties owed also to the people on the ground, but in the air. Duties owed, this is negligence. And reasonable care standard. The reason I point this out is that just on September 7th of this year, the judge turned this into a federal preemption case. And 5 days later, we had to resolve the case. But for 9 years, we're working on this concept. Was it foreseeable? Were the weapons detectable? Did they fail? Did they breach their duty in detecting and keeping weapons off of planes? We have evidence that from '93 on, there were over 600 hijackings. More than a third of them were hijackings where the plane was not used to get one person from one country to another, but to use the plane as a weapon, the weaponization of the aircraft as a goal of the hijacking. As the threat went up, security, we're ready to demonstrate, actually went down during that same period of time. So we had federal law to deal with, but we always viewed, and the court had been telling us for 7 years, to view the federal law as evidence or per se evidence of the negligence and the wrongful death conduct of the defendants. We had been working on that. We had building that case. We did over 200 depositions. We had millions of pages of documents that we discovered and analyzed. We prepared this case under basic concepts of wrongful death negligence. But we also had the federal regulations always as our barometer of per se negligence. One of the most important aspects for security screening was how you hired, and the requirements for hiring security screeners were they had to speak English, they had to have a high school diploma, and they could not have committed a felony in the past 7 years. I'll show you some of the net effect of the passengers, or the screening, the hiring that they did for those screeners. But the regulations even require common sense and good judgment. It was a requirement that people at the checkpoint, even if you're only sticking to federal regulations, that the checkpoint screeners use common sense and good judgment akin to wrongful death standards of reasonable care. But what had to be kept off of planes at all times were knives, tear gas, mace, chemicals, canisters, anything that could be used as a weapon. Now on Flight 175, there were knives, and none of those knives were confiscated to determine whether there were knives that could be allowed on the plane or not, because there are logbooks that would have shown that. And there was mace and pepper spray. Now mace was actually prohibited as a weapon. It was also prohibited as hazardous material. Mace could not come on board the plane with the passenger on 9/11, and it was on all of the flights, including Flight 175. It's just more regulations. So right after 9/11, Congress held some hearings right away, and some folks actually came to Congress and said, you know, I don't think box cutters, which were on 2 of the planes, 3 of the planes, I don't think box cutters were prohibited. People would have let somebody through with a box cutter all the time. Well, that's completely false. In the Checkpoint Operations Guide on 9/11, box cutters were explicitly identified as items that should not, cannot be on planes. Also knives with blades that were 4 inches or greater, or menacing. And menacing simply meant that if it had a jagged edge, no matter the length of the knife, it could not go on the plane. So every knife that got on a plane had to be inspected first to see if it was menacing. Mace and pepper spray and tear gas were also absolutely unequivocally prohibited that day. and every screener had to be able to read, write, and understand English. So my client, this particular client, we had over a dozen people on this plane, but this last client, Mark Bavis, sat in 19F. That's important because all the information from 175 came from somebody sitting next to him in 19E, a gentleman by the name of Peter Hansen. Peter Hansen made 2 phone calls that day, both to his father, and he gave us the most important information about what was on board that plane. A male flight attendant also reported that there had been a knifing, flight attendants had been killed, the pilots were killed, and that the plane was being hijacked. Peter Hansen called and told his dad that a flight attendant had been stabbed, somebody else had been killed, the plane is moving in strange directions. That's actually important for the wrongful death pre-impact fear components under Massachusetts law. And then Brian Sweeney, this is one of the passengers. His nickname, ironically, was Twin Towers. He was a fighter pilot before, and he called his wife, and this is a voicemail message that he left for his wife, Julie, another one of my clients.
Message 1.
Joel, listen, on an airplane that's been hijacked, and things will go well. I'm looking to, I just want you to know, like, absolutely love you. I want you to hear it, so have things to my parents and everybody. And I just totally love you, and I hope you accept it. Okay, bye-bye.
So he also called his mother right after that on a non-recorded line. And on that phone call, it turned out that he was telling his mother that they were actually about to try to take control back of the cockpit, sort of the way that the Flight 93 passengers were a little more successful at doing. Peter Hansen called back just before impact. He told a little more information to his father. The stewardess had been stabbed. They used knives and mace to carry out the hijacking. They said they had a bomb. It's getting very bad on the plane. Passengers are throwing up and getting sick. The plane is making jerky motions. I don't think the pilot's flying the plane. This is the only evidence, true evidence of what we know about the 21 minutes from documented conversations off of the plane. And for all of your evidence teachers, there are about 5 different ways to get this into evidence, even if it's only been reported through the 9/11 Commission final report. We just recently had, just 2-3 weeks ago, a transcript produced, and it had to do with air traffic controllers, and actually it was a very explicit description of them actually watching the planes hit the World Trade Centers, and so that was another bit of evidence. We actually had the recordings that we were going to share with our jury. And then we've sort of looked at each of the flights. There was pepper spray, threat of bombs, slashed throats, knives on 11, stabbings, knives, mace on 175. Flight 77 had box cutters explicitly excluded from 9/11 and knives. And 93 had knives, a gun, and some other, another threat of a bomb, I believe. This is the voice recording of one of the flight attendants from Flight 11. This is Betty Ong, and she spoke about what was on board that flight.
So returning to that, the conflict's not actually somebody stabbed a business class, and I think there's many that we can't read. I don't know. I think we're getting hijacked. Which one do you want? Flight 12. And there's somebody stabbed in business class, and we can't read in business class. Somebody's got mace or something. Okay, so our number 1 is got stabbed. Our person is stabbed. Nobody knows who stabbed who, and we can't even get up to business class right now because nobody can breathe. Our number 1 is stabbed right now.
Number
5, our first class passengers are first class galley flight attendant and our purser has been stabbed.
So flight attendants actually give each other numbers, and so the purser and the number 5 flight attendant had been stabbed. And that was one of the first reports that day of what was going on the planes. And this is another report. Beverly Burnett was one of our clients. Her husband was one of the 4 guys on Flight 93 that attempted to regain control. I won't play that for you because I want to get into some of the law. But she has a conversation with 911 and the FBI about what her husband was relating to her. So in looking at all of this, we know that they've got weapons on board planes that don't belong there. These are actual weapons recovered from the Flight 93 ground site. So this is a Leatherman knife. And we have evidence of what was actually captured from the ground, what was purchased by these hijackers before they got on planes just in the weeks before. The Leatherman knives are sort of those plier, multi-tool kind of things. They have jagged knives on them. There's one of the 14 weapons recovered at the Flight 93 ground site. And this is another component of that, of a Leatherman knife. For Flight 175, in looking at the purchasing records, we actually had clip hanger knives, Imperial Tradesman dual-edge knives, Leatherman tools, Stanley two-piece snap knives. These are the box cutters. We actually have purchasing records in the weeks before 9/11 of the Flight 175 hijackers. Muhammad Atta's bag didn't get onto Flight 11 when he transferred from a Portland flight, Portland Maine flight. So in his bag that didn't make the plane, we have some mace that was in his actual checked-in bag, and we have a box cutter that was recovered as well. These are handmade knives. It doesn't matter the length. If you've got a handmade knife, they have to be confiscated. These were actually recovered from the Flight 93 crash site, as well as jagged knives, Viper knives that were absolutely prohibited on that day. So what's our basic theory? We know from this litigation that the checkpoint is the place where you are, the airlines are required by federal regulation to keep weapons off of the planes and out of the sterile areas of the airport. So we have some of the folks who worked that day, and we took their depositions. And one thing we learned in taking their depositions is that the FBI hadn't talked to nearly half of these people after 9/11. These families were the single most focused group of people focusing on the issue of aviation security in the country. The FBI did not talk to every person who worked that day. We did. The 9/11 Commission was very focused on FBI, CIA intelligence failures. They had lots of missions. Their sole mission was not what happened that day. They were looking at a lot of policy issues, but they didn't talk to these folks that we spoke to. And they never reported some of the things that I'm going to show you that we found. These families had the ability to use the power of the civil justice system to find out answers that they weren't getting from the government, from government reports, from the FBI, or from the state police. One of the things we learned in this context was that although the federal law requires an understanding and an ability to read, speak, and understand English, we had to stop one of our depositions of one of the screeners for Huntley that day because she needed to get a certified translator to the deposition just to answer our questions. She's actually a beautiful person, a wonderful person that was set up to fail. She was put in a position she shouldn't have been put in. They were getting paid $6 an hour to do this. And she was put in a position to fail by a company that wasn't living up to the federal regulation requiring that they make sure the checkpoint screeners understand English enough. I won't play all of the audio tapes, but not only did we find out in speaking to this particular screener, and I don't even want to keep her, I don't want to, not only did we find out that she did not speak English well enough to answer our questions without a translator, we found out that she didn't know what mace was. Now, one of the things she was hired to do that day was to make sure mace didn't get on the planes. When mace was put in her hand, she didn't understand what it was. And it wasn't just her. It actually was many people. 4 different screeners that day for Flight 175 did not know what mace or pepper spray was when asked the question. And so we go back to the basics. One of the things they're also required to do is be trained in what aviation security levels are. You may not know what level orange is today, but you're not a screener. On 9/11, we were at what was called Aviation Security Level 3, which meant there was a likelihood of a domestic event, so you have to be on a heightened state of alert. Well, it seems innocuous enough, but when you actually go through who knew what that meant on 9/11 in their depositions, over 10 screeners didn't even know what the level was and what it meant. If that's not bad enough, 4 of their supervisors and trainers didn't know what the level meant. The same had to do with Al-Qaeda and Osama bin Laden. Now, Seth MacFarlane knew a year before, but 10 of the screeners on 9/11 didn't know who bin Laden or Al-Qaeda was, even though that's part of their requirement to know what the threat would be. And 4 of their directors and trainers did not know. So we had former United, every case has its person who comes out of the company to talk about what they knew and didn't know. And we had a United security manager who was ready to testify and tell us just how significant a failure it was at the checkpoint for 175, and going through the various aspects of what was permitted on board and why the screening process was insufficient. You may remember that, some of you may not, but before 9/11, when you got on a plane, you were asked two questions. Did you pack your own bag, and has it been with you the whole time? And they were laughable questions. I mean, who's going to say no to that question? You're trying to get on your plane, you go forward, all you have to say is yes, and you move on. Believe it or not, 2 of the 5 hijackers for Flight 175 could not answer that question. They didn't understand the question, and they couldn't answer it. They were brothers. One answered for the other. And instead of taking on additional security measures like examining the carry-on bags for those 2 passengers, the airlines, the ticket counter agent actually said, go ahead and proceed to the gate. So no security was done, even though basic information, basic triggering events for what makes a person a suspect or potential suspect threat, even with those red flags, nothing was done, even at the ticket counter, to stop and inspect. And I don't want to embarrass any of these folks, because the reality is that the person who made that decision to let them go through instead of do more to check those particular people who happen to be hijackers, she actually, in all of her performance records, was praised for her efficiency in getting passengers through the system quickly. She was being trained to set up to fail with respect to security. She was told that it was great that she could move things along. She wasn't being told you have to stop and take the time to make sure that you're screening people appropriately. So those are sort of the highlights of some of the things that we learned. Huntley had a success rate of only 79% when being tested by the FAA in 2001. So 21% of the tests the FAA did to try to get through Huntley's checkpoints with prohibited items were failures. And there were other examples just before 9/11 of the failures of this particular security company at that particular gate. And again, the average, this is probably the most striking fact on this point, the person who was responsible that day, the supervisor in charge that day, was 19 years old, and she'd only been on the job for 4 months. The average life of a screener in the system is 4.3 months. At $6, $6.25 an hour, it was actually more lucrative to go through the checkpoint and work at the McDonald's inside the airport than to work at the checkpoint and screen passengers. So, so what happened? And am I finishing up? Okay. So what happened in the end was, we were getting ready to try this case. We were gathering these facts. We spent literally tens of thousands of man hours. We've spent, I can't tell you the amount of money we spent investigating what happened to get the results, to get the information that these families took great risks to go get and make public. But in the court systems now, particularly mass torts in the business that I do, people are so quick to get protective orders in place where evidence isn't allowed to be shared with the public unless it comes out at trial or as part of some motion practice. So everything we gathered was under this blanket of protective order. And we actually asked the court in the middle of the litigation, some of these families, Your Honor, are here just to share this information, to put sunshine on this information so it doesn't happen again. That's the legacy they want for the person that they don't have as a result of 9/11. The New York Times joined us in a motion, and we asked the court, lift the protective order at the end of the litigation, let these families at least contribute what they learned to the 9/11 Memorial Museum. We're not going to go on TV, we're not going to do press conferences. Let this information be known. And the court said no. The court said that this information doesn't belong in the public, and even if it's old information relating to the past, I don't want to scare current passengers. I don't want to scare current travelers. So this information lay under the cloak of a protective order for a long period of time, and then just 3 weeks before, just 2 weeks ago, the court decided that it was going to, on the 4th attempt, that the defendants had to invoke federal preemption, the first 3 failing, the court decided that it was going to preempt all the state liability law, the wrongful death law, and call this a regulations case, a federal regulations case. And instead of the burden being ours to prove foreseeability, breach of duty, causation, damages, the court was going to allow the defendants to get up and describe their security plan that the FAA mandated and whether or not they lived up to it. And if they did, then we could then come back and try to show how they didn't. And so literally at the 11th hour, the federal court decided to turn this case. After 9 years and a decision of his saying that this is about duty and breach, the federal court decided to turn this into a federal preemption case. We decided at that point to respond to a pending summary judgment motion with 127 exhibits, identifying the entire story as best we could outline it so that this family could get at least their information out in the process of responding to a motion. And that information did get out into the public, and because it was a response to a motion, it was allowed to be out public and not protected by the protective order. And that final element of the motivation of this family was accomplished as best as the court was going to allow it. And so the case did resolve. The compensation numbers were never really in dispute because it wasn't for them about the number. The number was something that would always, we felt, and would always be there. But it was really about getting this information out. As soon as that information was allowed to be put out, our families, literally, to use their term, they found peace, they got the information out, and now they're going to continue to give voice outside the court system with at least some of this information, which I've shared with you today, that I couldn't have shared with you if this were scheduled a month ago. So there is plenty of information that's out there that I can't show you. There's information out there that's called sensitive security information, which means the TSA has said that if you share this information with the public, it would actually affect the safety and security of current passengers, and our families very much respected that. So we've never tried to seek that sensitive security information be let out to the public. But very important, relevant information and important sensitivities that even the TSA today could benefit from were in the documents that are within this protective order, and we've done everything we can to meet the client's goals of using the civil justice system to at least get that kind of peace for them, that their story could be told, if not entirely the way they had hoped, at least in a way that they felt paid some respect to their loss and to their brother Mark. The one final point I want to make about this trial, my client had a twin brother. And so in presenting this case, I was going to be in the position of having on the stand a person who was in the exact likeness, an inseparable twin. They both played hockey at Boston University. They both coached. Mark, who died, coached at Brown University. He played for the Providence Bruins, and when he died, he was on a scouting mission. He was an employee of the LA Kings hockey team. We lost in Mark, a tremendous man. I never met him, but I know him through the likeness of his identical twin and his wonderful family. And to find at the end of 9 years of litigation, and now having finished my last of the 96 claims, I find that the simple word that he texted me saying, "Thank you, Don, my family's at peace this weekend," to be the culmination of what I think the tort system can be, should be, and something that I hope if any of you go into torts or mass torts, I hope you remember, don't buy into the idea that it's just about the compensation. You can actually do something with what you get when you graduate from the school. Thank you.